today let's discuss about doctor's role in court as an expert witness and also a few practice MCQs. I have nicely explained about expert and layperson during the presentation of court system in Sri Lanka. However, just a little summary. Who is the expert? As you can understand, expert means any person who has got a very good, sound, professional education with practical experience. It could be any field, maybe engineering, maybe medicine, maybe something else, maybe carpentry work, right? Expert. In contrast to that, who is the layperson? Layperson means it's just a mere person who has not qualified with a certain educational degree or something. It could not be a degree, right? So the qualified person. Now you can understand who can give an opinion, who can give fact. Now always the layperson will give facts. It's just a fact, not an opinion. What do you mean by fact? Fact means anybody can perceive with 5 senses, right? So it's just a fact. Whereas to that, opinion means an opinion should be based on scientific teaching. To have that, this person should have a very good education and practical exposure about a particular field. You can understand now, experts will give opinion and layperson will give only facts. With that introduction, the court considers a medical officer with MBBS, as you can understand, or its equivalent, as an expert because of his professional education, training, experience that can be recognized by the court as competent to provide an opinion on matters of medical science. In contrast to that, and ordinary witnesses are testifying only to what they have directly observed. Then, an expert witness in forensic medicine specifically is a medical practitioner who, by virtue of specialized knowledge, training and experience that is recognized by the court as competent to provide opinions on medical matters relevant to legal proceedings. However, experts should limit to their educated fields, should not trespass someone else's field. However, giving evidence is a skill and also an art that should be mastered with the time. Our topic is doctor's role in courts. So now consider one by one now. Obligations and about etiquette. A doctor should obey summons. If you can't attend, inform the court well in advance or to registrar in writing with reasons, but it should be very acceptable reason. Arrive early. Do not leave without permission after your testimony. Dress formally. Males coat and tie, female sari or ladies coat. Be polite to judge, prosecution, defense and other court staff members. Speak to the judge. Maintain proper behavior. Well-mannered, and you have to respect especially judge or magistrate. How about the neutrality, truth and ethics? You are not for either party and never to win the case. Right? So now there are two parties, prosecution and the defense. Right? So you are not representing any party. However, you have to give your opinion. Right? So you are not trying to win your party. So this is a very good thing that you have to understand. Duty is to assist the court by stating the truth, right? So your duty is to assist the court by stating the truth. It should not be halfway, but the whole truth. Do not suppress or hide any evidence helpful to either side. Maintain independence, impartiality, and integrity as well. How about the scope and your limits? Testify only within your expertise. Know your limitations and pitfalls as well. Alright. So you have to identify your limitations and also your scope as well. Do not stray into fields you are not qualified in. If needed, seek a second opinion or peer review before the court visit. If you don't know an answer, Say so. All right, you can't guess the answer. If you contradict another expert's opinion, justify with special knowledge, research, or texts. If you need some more time to give a reasonable, good answer, you can ask for some time as well at times. Preparation and about reading materials. Read your notes, MLR, PMR, BHTs, and case files before the trial. Language fluency and matters. Yes, reports are often in English. However, there are instances where you can give evidence in Sinhala or Tamil languages. However, you have to rehearse with a colleague used to court work. Prepare to explain in simple, clear language. Avoid unnecessary medical jargon. Bring all relevant materials such as notes, reports, photos, charts, diagrams. Support opinions with textbooks, journals, guidelines, experiences, etc. etc. Role of the JMO as defense expert witness. Now, as I have explained earlier, state doctors basically represent the side of prosecution, or in other words, the state. However, a judicial medical officer may also be called by the defense party to give expert opinion. The reason is they are experts on the subject. They are not going to serve to one side only. Alright. So as a result, even the evidence ordinance is also identify a state JMO as a defense expert witness as well. The duty remains the same. Alright. That means to assist the court with truth and impartial medical evidence, not to support one party. Even when appearing for the defense, the JMO must be neutral, objective, and independent as well. These are really important parts that you have. Moving to the summary table of the differences of a layperson and an expert witness. Definition under the evidence ordinance, we are not going to discuss in detail as such. However, a lay witness means without specialized professional knowledge, whereas to that, expert witness means a person who has got a special skill and also a special training. Who they are? Ordinary person, no special expertise, ordinary person. Here, a specialist with knowledge, skill or training in a particular field. Could be medicine, forensic science. And the basis of the testimony. Here, a layperson will give facts, what they have personally perceived, what they saw, heard or experienced. Whereas to that, an expert witness will give opinions and inferences based on scientific or technical expertise. Scope of evidence. Lay people can't interpret or give conclusions. Just they give facts. However, in expert witness, they can assist the court to understand matters beyond common knowledge. To speak the truth about personal observation, right? To speak the truth about personal observation is a duty of a layperson, whereas to that, expert witness should give impartial, independent, truthful expert opinion. Example, a bystander describing an accident, what the person saw, heard or experienced. However, a JMO explaining of a cause of death in a case of homicide that the JMO didn't see or don't know about anything. Practice MCQs regarding the role of a doctor as an expert witness. An intern medical officer is an expert witness. What do you think? It is incorrect. The intern medical officer is still in his training period. That means he has got only the provisional registration from the medical council. That means he can't work alone. He can work under a supervision of a consultant. So, not an expert witness, not qualified yet. An intern medical officer is not entitled to summon to courts. It is incorrect. The reason is, if High Court judge thinks that the intern medical house officer should come and give some sort of testimony, yes, He can summon the intermediate health officer. If a defense lawyer is indecent to the doctor, he is also entitled to be aggressive back. Definitely incorrect. So that's why we have to know about how we have to behave during the court hearing. The doctor's role in court to support the party that he appears. What do you think? It is incorrect. A doctor or an expert witness should always support the court, not the relevant party. A doctor is allowed to hide information if that facts are not favorable to his side. Definitely incorrect. Using of medical jargon is acceptable. No, it's not. The reason is lawyers, judges can't understand medical words, so it's our duty to explain with simpler words rather than using any medical terms. Regarding the role of a doctor as an expert witness again, a layperson provides his opinions at the courts. What do you think? Is it correct? No. A layperson can give only facts. A judge dismisses the expert opinion if it is not up to the standards. Yes, it's correct. Judge has the discretion that if a particular expert witness is not up to the standards, yes, he can discard the evidence of the expert witness. A JMO is not allowed to appear for the defense. It is incorrect. If a JMO is a qualified person and can consider as an expert witness, he can go for either prosecution or to the defense as well, because he can support the court, not a special party. A JMO appears for the prosecution is allowed to charge a reasonable professional fee. It is incorrect because we are government servants and we are paid by the state. As a result, we can't get an additional fees for participation of the court case on behalf of the prosecution. However, if I happen to go on behalf of the defense, yes, I can charge a reasonable professional fee. To become an expert witness needs to master the specific skills. Yes, very obvious, correct. A doctor is considered as an expert witness according to the penal code. What do you think? True or false? It is incorrect. The reason is penal code defines crimes and punishments, and also it explains about illegal activities. All right. And what is the book that we have described in the court system in Sri Lanka? Another book that we have described, Criminal Procedure Code. It explains about procedural aspects of criminal laws, how cases are to be handled, and steps of the trial proceeding, etc., etc. That means Criminal Procedure Code. That means procedures are to be explained there. And what do you mean by the Criminal Procedure Code, right? Procedure Code. Criminal law procedures. All right. And then at the same time, what do you mean by Civil Procedure Code? That means the Civil Procedure Code governs the process of civil litigation, how the civil law is going to be handled. It describes the procedure. And what do you mean by evidence ordinance? It explains what evidence can be used in courts, who are the experts, what evidence can be relevant, what are the things that you can't use as evidence, etc., etc. So, a doctor is considered as an expert witness according to the penal code. It is incorrect. Thank you then.